Hello, my name is Sam Neiman. I'm with the League of Women Voters of Fremont, Newark, and Union City. This is a segment of a series of videos about the state propositions on this November's ballot. We will talk about Proposition 22, which is the proposition that changes the employment status of a rideshare or delivery driver back to independent contractor from where it is under current law as an employee. Before we get into the pros and cons of this proposition, I'd like to say a little bit about the League of Women Voters. The League of Women Voters is nonpartisan. That means we do not support or oppose candidates or political parties. What our mission is to encourage informed and active participation in our government, and this is particularly empowering and important during an election year. We work to increase the understanding of the public of public policy issues. We do this by educating our members and by educating the public at large. And additionally, if after serious study and consideration and consensus, we take a position on a public policy issue, we will advocate for that issue. One of the things we advocate for is voting rights. Now on to the proposition. This proposition exempts app-based rideshare and delivery companies, companies like Uber, companies like DoorDash, from providing employee benefits to certain drivers. This is an initiative statute, so it only requires a majority approval to pass. Let's look at the proposal directly. Effective in 2020, a law, Assembly Bill 5, passed in the legislature in 2019, established who is an employee versus who is a contractor. Employees typically get many more benefits, lots more benefits, because independent contractors don't get any benefits. The only benefit an independent contractor has is that they have they control their own destiny. They decide when to work, where to work, how many hours a week they'll work, things like that. Whereas employees, they are working at the schedule of their employee, but they do get sick leave, they get paid time off, they get holidays. It's a much different situation between an independent contractor or a gig worker and an employee. AB 5 used a three-part test. Is a person free from company control? Do they perform work outside the company's core business? And are they customarily engaged in the trades? And under this definition, gig drivers, rideshare drivers, and delivery drivers become employees. And that's very important for this proposition, because this proposition would like to change that. So rather than Uber, Lyft, DoorDash drivers becoming employees, they would remain independent contractors. Now, during the crafting of this legislation, there were many organizations that work with labor, and they worked to make sure they were outside of the auspices of AB 5. They would be people like professional dentists, doctors, conductors, certain artistic professions are not covered by the law AB 5, so they are not affected by this either. So what this proposal is that drivers stay independent contractors, but in addition to that, they will get some benefits from the companies they work with. The driver's pay would go up to 20% over minimum wage for any time driving, and they would receive 30 cents a mile for any driven miles. They would get a health care subsidy. That health care subsidy, if the drivers are driving at least 25 hours a week, would be the amount up to 82% of an average covered California healthcare policy. If the drivers are working between 15 and 20 hours a week, they would get a subsidy, but it would be lower. And there would be additional medical coverage provided for drivers for injuries on the job. Drivers would be provided with insurance to cover medical expenses and a lost income up to $1 million for any injury that occurred on the job. Also, there would be disability insurance for drivers, which would give them up to 66% of their pay if they are disabled on the job. Lastly, what I have written up here is it restricts drivers to only 12 hours a day, and this is a safety protocol. There are a couple other safety protocols that I don't have up on the screen, and these companies would have to prohibit workplace discrimination. They would have to require the companies to develop sexual harassment policies. I always like the way that's written. We would not have them develop policies for sexual harassment, but against sexual harassment. And to conduct criminal background checks on all the drivers. Lastly, mandate safety driving, safety training for the drivers. So those are the things that the companies would give, and in this case, the drivers would stay independent contractors. There's one other little tidbit here that I find kind of interesting. It stays the ability of local jurisdictions to make any changes to the employment status of the drivers. They can't ask for anything more or less. So what are the fiscal effects for the state? Well, basically, not very much. We might get some higher income tax receipts because the drivers would be making more money. But it's really the companies who would bear the higher cost in providing benefits defined in Proposition 22. Right now, these drivers get, under current law, this is a little confusing, this one. Under current law, AB 5, drivers are employees. However, that is being litigated through the courts right now. The state, as I said, has been suing these companies to start treating these drivers as employees. But under current state law, companies are supposed to be giving full employee benefits. Okay, but there's really very low impact to the state. So let's look at the supporting arguments. Classifying the drivers as employees will give higher prices and less access to delivery services for the public at large. And again, I have to stress a yes on this. Drivers stay independent contractors with some additional benefits that they have not had prior to AB 5. Okay, it protects drivers seeking part-time work, it brings new benefits to drivers, and it provides more protection for customers. Those protections are the limit on the number of hours driven, the background checks, and the driver safety training. Okay, so let's, did that a little strangely. Now let's look at the opposing arguments. The opposers, the people opposing us, are saying it eliminates basic workplace protections, replacing them with a lower guaranteed earnings and health care. Again, a no on 22 says we consider gig drivers, rideshare drivers, delivery drivers as employees of companies like Uber, Lyft, and DoorDash. The current law does not reduce driver flexibility, and companies should not get to pick what laws they want to pay attention to, or basically write their own. And what the opponents are saying is they are writing their own laws with this proposition. So it's sometimes challenging to figure out, as you're reading the supporting and opposing arguments, and to suss out what's really going on. So what I like to do is I like to look at the money. Where's the money flowing in support and opposition of these arguments? There's a couple ways you can do that. You can go to the Secretary of State website, and there you can drill down into the ballot measure and see quite a number of ways of looking at finances. You can actually look at Voters Edge, a league website, and get that information as well. I am also very interested in a website called the FPPC, the Fair Political Practices Commission website. They have a transparency portal that lets us look into where monies are flowing into committees and PACs. And when I looked at the money in this one, the things that I found most interesting was when I looked, and these websites are updated with new information quite frequently, so you may want to look at them right before you vote. But when I looked at the FPPC transparency portal a few days ago, there was about $183 million for the support of this. And all of those contributions came from the app-based rideshare delivery companies. In the opposition, which brought in about $7.5 million when I looked, were mostly labor unions here in California and those headquartered in DC as well. So this gives you kind of an idea who's favoring this, who's against it, and it kind of helps you make up your mind if you know who is putting their money where their mouth is, so to speak. So to help you, I've put together a list of websites that are nonpartisan information. Of course, I started with our website. There you will find links to others, including the League of Women Voters California. All of the league sites have links to election information, ballot measures on LWV, FNUC. We also have links to candidate forums for the Tri-City races, be they the mayor's race, the city council's race, the school district's race. You can look for yourself and see what the candidates are saying about what they will do. Voters Edge is a pretty comprehensive site, and that site you can go look at the candidates, everything. It drills down a little bit deeper. If you're busy and don't want to spend all that time, you might just want to go to the Easy Voter Guide. The Easy Voter Guide is a concise, like an executive overview, but it gives you enough information that you would feel more confident making a decision on these ballot measures. I list the Legislative Analyst site, which does analysis of all the ballot measures, and of course the Secretary of State site. CA Votes is another great site, as is Cal Matters. I like that one for younger people because it's pretty snappy and it gives information in kind of a fun, almost game-like way. So please take your time, look at these, look at Ballotpedia. They are backed by a nonpartisan site and they are considered neutral. So look at the rest of the propositions on our website. Look at the candidate forums, and I encourage you to join the League of Women Voters, and I thank you for voting.